Has expired. The chair now recognizes Congressman Gowdy.
I thank the Mr. Chairman. Ms. Nkapi, among many limitations in life is my inability to glean other people's motives or be able to read their minds. I could have sworn in response to a question you received from Mr. Cohen, you suggested race was the basis for why we may have this constitutional perspective. Did I understand you correctly?
I believe I was responding to the question about is there an explanation about why?
Well, let me offer another explanation to you, okay? Not a single Republican who is here right now ever served under a Republican president. Not one. So I hope I do live long enough to hold a Republican president to the exact same standard that I'm holding this one. But for you to run to race as the explanation for why we hold the position that we do. Harry Reid had a very different perspective on recess appointments when there was a Texan in the White House, and none of us accused him of geographic discrimination. In fact, hell, for that matter, Senator Obama had a different perspective on executive overreach than President Obama, and nobody runs to race as an explanation for that. So I would just caution you to be careful when you try to import motives to people. With that, what are the limits of prosecutorial discretion?
So among the limits of prosecutorial discretion is that the president must comply with existing statutes such as the appropriations. So the president can't simply stop deporting everybody. And in fact, what they've done here is they've listed new priorities.
So he can't stop deporting everybody. Well, I mean, what are the limits? So as long as he deports one person, then that's a proper exercise of prosecutorial discretion?
No, under the current appropriations, I'm
not talking about appropriations. I'm talking about the constitutional doctrine of prosecutorial discretion, which if you marry up with the pardon clause means you don't have to enforce it, and if they do break it, you can pardon them for it.
Right. So under the constitutional doctrine, we should take two pieces. One is you've got the take care clause, which says that the president must take care to enforce the laws.
Ms. Nkapi, your answer is much more complex than my question. What are the limits of the doctrine of prosecutorial discretion?
The limits are that the president must enforce the laws based on statute. So one is...
I thought he just announced he wasn't going to do that he was carving out categories and exceptions.
In addition,
and not on a case-by-case basis, too, for entire categories.
No, he is not stopping. He's not saying that he is not going to enforce the law whatsoever vis-a-vis those individuals. He is saying he is creating a program by which individuals can come forward if they meet certain criteria, and they will be held accountable to apply, pay a fee, pass a criminal background check.
But that's not the current law, right?
That is what is possible under deferred action, and that is what he has developed. Correct.
Well, I want to talk to you for a second about that background check, and I want to get into the policy a little bit. Can you tell me what a non-serious criminal is? Because when I look at the White House talking points, they're interested in serious criminals. So tell me what a non-serious criminal is.
It could include somebody, for example, who has been detained for shoplifting. Let's say a 22-year-old who takes lipstick, and that's a misdemeanor. And she. So
just misdemeanors. A non-serious criminal refers to misdemeanor convictions.
Right, and in fact, there are certain misdemeanors that are considered serious criminals under the recent memos from the Department of Homeland Security as well.
How about domestic violence? How many domestic violence convictions can you have and still remain?
I believe domestic violence is considered a serious crime under the new...
It wasn't under the comprehensive Senate immigration bill, which I have heard lots and lots of my colleagues embrace. I think you could have up to 3 domestic violence convictions and still remain on a path to something under the Senate version. How about recidivist DUI?
I believe DUI completely disqualifies you as well.
A single DUI conviction
correct,
is considered a serious criminal, even though it's a misdemeanor.
That is my understanding, yes.
Well, where could I go to find out whether or not that understanding is correct or not? It wasn't on the White House talking points. They talked about gang members, but I'm not aware of a federal crime for being a member of a gang. Is there one? I know it's a sentencing enhancement. Is there a crime for being a member of a gang?
Well, in fact, that is some of the concerns that some advocates have, that if you are being considered a gang member because you live in a certain zip code and you're being associated, or is it really based on...
Well, I understand your concern is that it might catch too many people. My concern is the opposite, that it won't catch the right people. So it's not a crime to be a member of a gang. You have to commit another underlying offense, and then it's a sentence enhancement. So how are you going to determine who the gang members are?
Well, there are gang databases that exist. We assume, again...
So if you're in a gang database, will you be deported?
We don't have enough information from the administration yet, right? Remember, this was just announced.
Well, I've got the talking points that gang members are going to be deported.
But the talking points are not sufficient. They will be issuing guidelines with respect to how they will...
Who is they?
The program. The administration, the White House, and the Department of Homeland Security.
Thank you, Mr. Chairman.
Professor Tiefer, would you seat a juror who referred to your client as an obscene body part?
I'm sorry.
Would you seat a juror in a trial who referred to your client as an obscene body part?
I really have trouble giving you an answer, except that sounds
Well,
like
then
that.
you would starve to death as a lawyer if you can't answer that question, Professor. You would seriously consider seating a juror in a trial, a criminal trial where your client was accused of a crime. If that juror had referred to your client as an obscene body part, you would struggle with whether or not to strike that juror?
Well, it doesn't sound too good.
No, it's not. And I'll give you some free litigation advice. You'll want to use one of your strikes on that juror. How about if you were a prosecutor and one of the potential jurors referred to the police as terrorists who are going to bring the country down? Would you seat that juror in a criminal prosecution if you were the prosecutor?
I wish I saw the connection here, but...
I'll give you the connection. Lois Lerner just referred to conservatives as an obscene body part, and she said we were crazies and likened us to terrorists.
Well, Mr. Chairman, if...
You are not recognized. The gentleman from Georgia is not recognized.
Well, would the gentleman yield?
No, sir, I will not. Let's go to the regulation, Professor. Conflict of interest for the department. People like standards. They like bright lines. So I thought it'd be interesting to go find out what the Attorney General's standard is for recusal. And you know when he recuses himself? I'll quote him. When there's the potential appearance of a conflict, he recused himself from a criminal prosecution when there's the potential appearance of a conflict. Those are his words, not mine. So that's the standard for when there should be a conflict. I want us to analyze whether or not there could possibly be the potential appearance of a conflict. You have the President of the United States. When I ask a question, it'll be very clear, Professor. The President of the United States, in the most widely viewed television show in our country, said there's not a smidgen of corruption. You don't think that is the potential appearance of a conflict?
For the issue of a special counsel, which is what I'm here for, I think.
How about give me a yes or a no, and then you can explain your answer.
I think it's irrelevant what the president says to whether there's a conflict of interest.
What if a judge says, let's go give this guilty bastard a trial? Is that irrelevant? Would you want that judge? If he prejudged the outcome of a prosecution and said, let's go give this guilty guy a fair trial.
Given the independence of the public integrity section for the last 30 years, I don't think it matters what...
So you don't think it matters that the chief law enforcement officer for this country, before there is an investigation, while there are emails missing, before he's analyzed one scintilla of evidence, prejudges, and says there's not a scintilla of corruption? You don't think that matters? You don't even think it creates the potential appearance of a conflict?
I absolutely reject that the standard here is the standard you're naming for recusal. If he recuses himself, it's still the same justice.
How about when the
without a
Department
special
of Justice
counsel who does
trades
only the
emails
Attorney
with
General?
Lois
Sorry.
Lerner seeking to implement an idea from a Democrat senator? Do you know Senator Whitehouse?
My understanding is the idea was rejected after the meeting in question, that the idea was...
I'm simply saying, do you really want the Department of Justice and the IRS taking their prosecutorial advice from a Democrat senator? I thought the Department of Justice was blindfolded.
I'm glad they rejected the idea.
I'm sad that they even discussed it. I'm sad that they even discussed pursuing, because when the AG sits where Professor Rotunda is, all we hear about is how he doesn't have the resources to actually do his job. And now they're going to contemplate manufacturing false statement cases?